And I give the floor to the representative of the Russian Federation in French. Thank you, Mr. President, in Russian. I am glad to welcome you, Mr. Minister, as our President. I'd like to thank the Deputy Secretary General, Ms. Mohammed, the Director General of ICRC, Mr. Mardini, and Ms. Grosjean for their informative and substantive briefings. The topic of today's discussion is truly multifaceted. We, of course, condemn unlawful actions against humanitarian workers. We advocate giving them unhindered humanitarian access, as long as there is the consent of the host government. The time factor often is a guarantee for success of humanitarian efforts, the aim of which is to mitigate suffering and often to save lives. However, recently, in a number of countries which bear the brunt of armed conflicts, we note a dangerous trend whereby the governments of the states in need are baselessly accused of apparently trying to block humanitarian access. Without providing explanations and without bothering to find out what is going on, many donors think it is within their rights to dictate their will to sovereign states and even to threaten them with investigations. We'd like to remind colleagues that all humanitarian work should be carried out in strict compliance with the guiding principles of humanitarian assistance enshrined in the UNGA Resolution 46/182. A key principle of this is the consent of a state when providing assistance and the subsequent coordination with that state regarding steps taken in humanitarian operations. This is the key to the security, neutrality, and impartiality of humanitarian work. In this context, I would point out the concept being actively promoted in the UN just now, the so-called humanitarian space, raises nonetheless a lot of questions. At its core and hidden behind eloquent slogans, in essence, is a desire to grant some kind of immunity to humanitarian workers when agreeing upon and carrying out their work. In practice, this might lead to a breach of sovereignty in terms of initiating and managing humanitarian assistance. So this runs completely counter to the principles of Resolution 46/182 of the UN General Assembly that I mentioned. Mr. President, of particular concern is the humanitarian situation in territories controlled by terrorists and their associates. The task of promoting humanitarian staff in such territories has become much more complicated. As a rule, fighters demonstrably flout the norms of international humanitarian law and indeed flout any principles and rules of human conduct. Clamping down on terrorism is only possible jointly. For this, there is a need to reject double standards and to stop exonerating, either politically or through terminology, to stop exonerating those people who are preaching and promoting extremism and terrorism. The importance of unfettered deliveries of humanitarian assistance in areas of armed conflict is no doubt whatsoever. Nonetheless, the goal of creating propitious conditions for the work of humanitarian organizations and medical staff in and of itself should not be used as an excuse for states to fail to uphold their obligations to counter terrorism. It is unacceptable for medical and humanitarian organizations directly or indirectly to assist terrorists, thereby undermining international counter-terrorist efforts. In this regard, something that is still pertinent is Security Council Resolution 2462. In line with this, states, when they're implementing relevant measures, states should only consider the type of humanitarian work that is impartial and which is strictly in compliance with the requirements of IHL. Mr. President, we have always promoted the need for prosecuting for crimes under international law. Unfortunately, the experiment with the Security Council transferring situations to the International Criminal Court has been a failure, as, in fact, has the practice of establishing ad hoc tribunals. Given this, some states have striven to prosecute suspects in their territories based on the concept of universal criminal jurisdiction. We have always been very cautious about the expansion of this concept, which, as we've seen from practice, is subject to abuse. It is precisely because of this that the long discussions on this in the UN are still fruitless. There's not even a glimmer of hope for consensus on this. In these circumstances, we believe that the main role in eradicating impunity should be played by the national judicial systems of those states where the alleged violations took place, and the accused should be prosecuted in line with the severity of the crime. Mr. President, a key part in overcoming crisis humanitarian situations is a key part of this is rejecting the flawed sanctions pressure and blockades, the use of those. Unfortunately, the expanded use of politically motivated unilateral sanctions has become a reality today. This is a wanton practice, as in particular is the use of secondary restrictions, especially extraterritorial ones. They are all a breach of the sovereignty of the state and also represent interference into its domestic affairs. We specifically reject the use of unilateral sanctions to overthrow so-called rogue regimes through economically suffocating states or upsetting the domestic political situation in that country. Such actions demonstrate an archaic two-block type of thinking, and it leads to upping the ante and increasing tensions in international relations. Sanctions are not commensurate with the principles of international cooperation, and they should not be restricted, even if those especially in those areas where there's a real need for pooling efforts to combat contemporary challenges. Thank you very much indeed.
Je remercie le représentant de la Fédération de Russie. Je donne la parole à...
I thank the